Johan, maybe you can answer this question that I get a lot. Voetstoots. What is Voetstoots, and when does this condition apply and when does it not apply?
Amore, Voetstoots is let's call it a dreaded Dutch word that we basically inherited from the Roman Dutch law. It's a part of our common law, but it is still very effective. We just have to distinguish between Voetstoots in the event of private sales, and then Voetstoots in the event where there is a physical supplier in the true sense of the definition as prescribed in the Consumer Protection Act, because it basically has two different approaches. Voetstoots in short and narrow terms basically means the following. I, as the seller, have told you everything that I literally know or reasonably ought to have known about the property. This includes patent or latent defects. So I'm not hiding anything from you. I'm giving you the property in the current state as it is, and whatever I had knowledge of, or as the law also says, reasonably should have had knowledge of, I've disclosed. So if something would surface after that date, being the operative date is the date of signature of the agreement, if something would surface after that, I can call upon the Voetstoots defense to say, I was not aware of this specific aspect, and therefore I cannot be kept liable. Now, it's important that the burden of proof to show otherwise is always on the shoulders of the purchaser, and there's case law to that effect. So you've got to remember that if you want to keep the seller liable, irrespective of the defense of Voetstoots, you've got to be able to prove that he knew about it, of the defect, or reasonably ought to have known about it, and he obscured it. In other words, he deliberately failed to disclose it to you and tried maliciously to conceal you in that specific regard. But it's a very powerful remedy, because you can imagine that burden of proof of the purchaser is immense. You are just moving into a newly purchased property in Queenswood, for example, and suddenly there's a leak in the roof. How am I, as the purchaser, going to be able to prove that you knew or reasonably ought to have known? Unless I can bring in a witness that says, no, you've been repairing this roof for quite some time, so you had to have known about it. So
the burden also lies on the buyer also to make sure that when you view a property that you have done that thoroughly. That means if you want to open the taps, if you want to check in the roof, if you want to go around the property, that's your prerogative to make sure that you know exactly what you're buying. And that then lies to go back to the truth that you have been saying. How would you know that the leaking roof is the truth?
That's a very valid point that you make. And I think this is something that a lot of purchasers take very lightly. You know, they go into a property like a whirlwind, have a look at the property, and seemingly everything is in order and it's fine. But there is a Latin expression which equally comes from our common law called caveat emptor. In other words, beware the buyer. The buyer has to acquaint himself thoroughly of the product that he's purchasing. Because if it's a patent defect, in other words, something that could have been seen with a naked eye or picked up by means of a reasonable inspection, that cannot be thrown back to the seller to say, you've got to fix it. In other words, that's something that I should contractually demand to be fixed. And if not, it's basically as if I've accepted it because I should have established it by means of my reasonable inspection or not. So that's of the utmost importance. So Voetstoots, very important. But that brings us to Voetstoots in the event where you purchase from a supplier. Now, in terms of the Consumer Protection Act, a supplier is a person who provides goods or services in the ordinary course of his or her business. That makes it a little bit more difficult to raise the defense of Voetstoots as a supplier, because there are increased standards of quality that the Consumer Protection Act requires of me as a supplier. The reason why we haven't touched base on this in the event of a private sale is that that seller doesn't sell the house in the ordinary course of his business. There's a CPI, or the Consumer Protection Act, does not apply in that instance. But where I, for example, purchase a property from a developer whose job and whose specific function and ordinary course of business it is to produce houses, we get a specific clause in the Consumer Protection Act, more specifically Section 55, in terms of which he gives you implied warranties. He says, if I sell you this house, it would be reasonably suitable for the purpose that you're going to use it. It will be free of any defects. Now, that's quite severe because I don't know of any townhouse, for example, that doesn't have defects. But then that specific developer has a responsibility to repair those defects within a reasonable time. And the period in which they guarantee the suitability of the product is currently 6 months. Now, if that is not the case, you have restitution rights in those regards, and he cannot claim that he sold the property to you, Voetstoots. So you have to have a look at the different approaches, those private sales where the Consumer Protection Act doesn't apply, and then obviously where you buy from a supplier where the Consumer Protection Act does hamper the raise of the Voetstoots defense. Even the Consumer Protection Act makes provision, I'm talking under correction, I think it's section 56, makes provision for the fact that I can sell you a specific article or a product in a certain condition. So I can, even as a developer, say, well, you know, I'm selling you the second-hand townhouse, which I've been renting out for quite some time, and it does have certain defects. We're going to stipulate the defects, and you're going to accept those defects per se. So then you cannot come back and rely on the Consumer Protection Act to obviously aid you in that regard. So it's a very thin line of balancing, and you've got to determine, maybe get legal advice in advance before you acquire the property to see what type of legislation and what common law practices are applicable.
Great. Thank you, Johan. I appreciate your time.
Only a pleasure. Thank you very much for having me.